If data are the new fuel of global economy, how can foreign politics support citizens' digital rights and privacy in an ever more complex digital world? How can democracies and citizens as consumers be braced to face even more powerful digital data giants? What regional efforts to promote digital rights are unfolding in Latin America, the Caribbean, and Europe? What can both regions learn from each other to strengthen the enforcement of digital rights? Data protection and digital rights.
Hello, everyone. All of you very welcome. Just introducing myself briefly, I'm Eduardo Magrani. I'm the president of the National Institute for Data Protection in Brazil. I'm a postdoctor at the Technical University of Munich, affiliated at the Berkman Klein Center at Harvard University, and partner at the Marest law firm in Brazil. So be very welcome. Feel free to ask us questions. I'll be seeing all of them for our Q&A. I have a team of all-stars here with me in this afternoon. I have on the first hand Katitza Rodriguez. She's EFF's Policy Director for Global Privacy. We have also Emmanuel Letouzé, Director and co-founder of DataPop Alliance. We have Estelle Massé, Senior Policy Analyst in Global Data Protection and Global Data Protection Lead at Access Now, and Eduardo Bertoni, Director of Argentinian National Access to Public Information Agency. As I said, it's an all-stars panel. I'm very, very glad to have you all on board. We're about to have a very productive conversation about data protection and digital rights, talking about the interfaces that we have between the European Union and what we have in Latin America nowadays. Instead of making more introduction, I would just like to jump into our conversation, in our discussion, starting to ask, firstly, Estelle, maybe, as a kickstart about the European level, trying to think, for example, what GDPR is representing nowadays. What changed after GDPR? Because it got viral in many parts of the world, right? So I think it's a good starting point for us to, after 2 years of the GDPR getting into force in Europe, we have different feedbacks about how it's going, feedbacks from the European Commission in the latest report and some others as well. So in your perception, Estelle, what does the GDPR represent in global data governance? What changed after GDPR? Because in many European countries, we have this privacy culture for a long time now. I'm based in Munich, in Germany right now, and Germany has privacy law since the 70s, for example, and regulation of data protection officer for a long time. And just to cite a few examples. So in your perception, what does the GDPR represent nowadays, not only to Europe, but I would say globally? This is just a warm-up for us. And to each question, I would ask you to be limited to up to 10 minutes, if you can, just to keep everything on track in this moderation. So please, Estelle, be very welcome once again.
Thank you very much. Thank you for the invitation and for giving me the floor. I'll try to be brief and even maybe under 10 minutes to also test the perspective, since I will be presenting it from a European perspective, but I'll be curious to hear what others on the panel may be thinking. And I'll do my best also to try to see not just what it meant for Europe, but try to start talking about the global impact in particular, also with a focus on Latin America. So thanks again for this question and for the invitation. So as you mentioned, the General Data Protection Regulation for Europe was not necessarily a revolution in the sense that Europe has a long tradition of protecting personal data. We have had legislation in place and binding rules for more than 20 years now. We have been signatories also of the known Convention 108 from the Council of Europe, which is the only international treaty that protects data protection globally, which is also signed by a lot of countries in Latin America. And so for us, the GDPR was more an evolution to our data protection rules to the digital era. Our previous rules dated to the pre-internet era. It needed to be upgraded and it needed to be also given a little bit more teeth in terms of enforcement power and sanctions, so that to make sure that a digital actor would not only respect the rules, but also be deterred from committing data protection abuses. As you mentioned, there was a lot of talks when 2 years ago it finally entered into application. It's already been 4 years since the institution voted on it. And we're still seeing, and we definitely see the GDPR as a massive legislative success for Europe. It's clearly one of the flagship laws of the continent, one that has put Europe as a global leader in terms of regulation for the digital era, in the era of privacy. It's a legislation that is being not necessarily copied, but looked into where countries get inspiration from to learn from the good things, but also the bad things, or the things that are probably truly European and don't have to be replicated elsewhere because it's just part of our culture. But it has created this global dialogue for data protection. And I think we're at a stage where 2 years in if we talk about norm setting, the GDPR has been extremely useful in creating this dialogue globally for global convergence. And in particular with Latin America, we truly see this convergence because we are both continent with a similar history in terms of our relationship to law and binding rules. Latin America also had a lot of ties with Europe, previous data protection law having so-called adequacy decisions where our norms were deemed to be equivalent. So what has happened in Europe has created a lot of debate in Latin America. We have also seen the recent development in Brazil and how countries are developing for the first time their stronger data protection law. So I think we're both part of this global convergence conversation. Now you alluded a little bit to it of like not everything is a clear success, and there is also different feedback on how this is going with the law. And recently we were discussing in an event in Brussels the sort of first few years, some of the feedback. And while the legislative side is a success, the enforcement side is a failure so far. And it's a failure not because there is an issue with the law, but there are a series of hurdles that makes the work of data protection authorities very complicated. A lack of resources, even though those have increased, but just the task they have ahead of them is so huge that they need even more resources. A lack of political commitment from the EU member states that have voted for these laws but are not putting the means or are putting barriers to their enforcement because of the complicated relationship with some of the large companies. And a failure also of enforcement because the GDPR created a new system that forces all EU regulators to work together, and this is proving to be quite difficult. Even though they had the habit of meeting regularly, they now have to take a lot of time decision together. And here you can still see that even though we're one continent, there are differences in the way we understand certain norms and certain rules everywhere. And we're all interpreting also a new law. So all of this will take time. And we know we need to give it a little bit of patience. But I have to say that from the end user side, we've done our job a little bit in the sense that a lot of complaints have been brought. We have new rights, we've used them, exercised them. There was a lot of enthusiasm when GDPR came about. And so now it needs to be translated into action. If not, we fear we will see a sort of return of a business as usual where data protection is considered as something in a compliance that you need to tick from time to time, but don't have to worry too much because regulator will not enforce, meaning that in practice your rights will not be delivered. And we really need this enforcement to come for people's right to be protected, but also for more innovation based on privacy to be upgraded. And so this is perhaps the second part of the convergence discussion that needs to continue happening within forum like the Global Privacy Assembly and the different networks of DPAs to ensure that the difficulties that DPA may be facing also are discussed globally, that we learn from each other's experience, but also we really put the focus on it, because it's great if we have maybe one of the world's best data protection law, but if it's not being enforced, it's a nice declaration we can put on the wall and that will be it. So I'll leave it there for introducing the discussion, but I look forward to hear what others may have to say about the GDPR and how they see it or how it may have influenced discussion in their own country.
Perfect, Estelle. That was an excellent kickstart, and you gave me the right opportunity to take it back and to pass the word to our other panelists taking the perspective of the enforcement. So as you said, the GDPR is a very important pillar on the European governance. But even though it's into force like 2 years already, we still lack some political commitments, as you mentioned, and also resources to foster data protection authorities, so on and so forth. But it was indeed a very important pillar worldwide, not only inside Europe, but for the whole world. It kind of got viral. So I'll take from there, from your excellent introduction, and I will ask Katitza and Emmanuel to a quick reaction about it, trying to explain for us what GDPR represents in Latin America so far, because many countries were heavily influenced by GDPR. But in what sense? How far they went in this kind of inspiration or mirroring GDPR? Is it the same? Does it have like still many gaps? And if it's different, in what sort of level? And also trying to address not only the role that GDPR represents and plays in Latin America, but also the question of enforcement. Because if we have a lack of enforcement in Europe, it wouldn't be different in Latin America. So when we talk about the importance or lack of enforcement, what kind of challenges are ahead of us? So please, if we can start with Katitza, be very welcome.
Eduardo, thank you for the kind invitation. It's my pleasure to be here with you all today. So in Latin America, we already have several laws, even before the GDPR, that have adopted data protection laws in Chile, Argentina, Uruguay, Mexico, Peru, Colombia. And just most recently, after the GDPR, the adoption of the GDPR, we have certain laws like Brazil and Barbados that are inspired by the GDPR. And recently also Panama, which is a mix of the GDPR and the previous directive. So what I'm going to say, what I'm saying is that the data protection directive already have been very influential when it comes to drafting data protection laws in the region. Also, it comes because on our constitution, in certain constitutions, like in Mexico, data protection is a fundamental right. Some others have developed the right of data protection through the concept of habeas data, or also the Constitutional Tribunal, who are the maximum interpreters of the Constitution, have developed the right through that means. So recently we have finished a comparative analysis of privacy and data protection laws in Argentina, Brazil, Chile, Colombia, Mexico, Paraguay, Panama, and Peru. And we found that exactly there are two new laws, Barbados and Brazil, who are very in line with the GDPR or inspired by the GDPR. And that's these are the most modern data protection laws in the region. But when it comes to data protection in the law enforcement context, like the European data protection, the European Police Directive, that trend hasn't migrated in Latin America as it is in Europe. We only have Mexico who have adopted a kind of law that deals with data protection in the context of law enforcement. There are bills in discussions, but they're not actually a trend, and we would like to see more of that. I think that is very important. Some of the developments in the European Union, especially after the Trump's decisions about the intersection of data protection and government access to data, will be very useful in Latin America. The principle of data minimization and purpose limitation in the data protection world correlates to the necessity, adequacy, and proportionality under international human rights law. They are very important to stop unrestricted access to data retention or massive data retention laws that we see in several countries. The idea that any personal data requires a legitimate basis, uphold the basic principle of legality and legitimate aim, to place limitations on government access to data. Law enforcement access to communication data must be clearly and precisely prescribed by law. No other legitimate basis is acceptable. So voluntary disclosures from companies to governments are not acceptable and need to be prescribed by law. Anyway, there's a lot of things in the intersection of data protection and government access to data that needs to be strengthened in the region. When it comes to the authority, the new data protection law in Brazil, and this is what the work that the local NGOs are doing, and I was reviewing their work also with Access Now, that there is a problem with the data protection authority in Brazil. First, it's under the control of the president. It doesn't have the same level of independence as, for instance, other regulatory agencies in the country. But in addition, some of the members on the committee have a military background. And this is very problematic in Latin American countries. I will talk later a little bit about the influence of the military in decision makings. So in Brazil, this is problematic, and I read maybe Estelle can talk a little bit about the work that they are doing, calling about the European Union to try to ensure that, the independence of the authority in that country. This is important because in Brazil, the DPA is responsible for the interpretation of the law and to apply the sanctions. So when it comes, for instance, as a concrete example, when it comes to companies' obligations to carry impact assessment of personal data, the Gdpr, for instance, explained that data controllers should carry out impact assessments prior to high-risk processing of personal data and provide examples when such processing or such assessment must occur. But in Brazilian law, there's no clear prior obligation. The law only says that the data protection authority will determine when the controller will carry this impact assessment, when the processing may pose a high risk to fundamental rights. And so there is a lot of delegation in the data protection authority to interpret the law, because the law has less details than the GDPR. And so having an authority that is not independent, and that in addition of the independence is composed by people from the military, with military background, with little expertise on data protection, it's concerning. Just to finalize, when it comes at the intersection of processing of personal data by public authorities, the DPA will also be able to suggest the adoption of good practices. In countries where the rule of law, democracies are not as strong, this could be very concerning. We just see the scandal of Cortex, the use of the intelligence agency's access of a database of license plate readers, combining it and cross-reference with employment data from another ministry and use it in a very disproportionate way. So that's why we need to ensure that these laws have teeth in both against companies, collections, protect our people's right against company collection of processing of data, but also against the use of databases by public authorities. And to finalize, a little just a matter of context. When it comes to intelligence agencies, many Latin American agencies were formed under military rules, usually born under military dictatorships. And within that that period, some agencies were created under conditions that were not the most transparent or the more democratic ones. There is also a lot of experience about the use of intelligence agencies in the region for presidential politics, to spy on dissident groups, opposition politicians, or independent journalists. We have seen it in Peru, we have seen it in Colombia, we have seen it even in Argentina. And most recently, we have seen that in Mexico and the use of this database of Cortex by the Ministry of Justice Integrated Operations Service. So we have concerns about also in ensuring that the data protection toolkit apply to both, to also the government, the databases handled by public authorities. That's all.
Thank you very much, Katitza, for the always very insightful inputs. You brought us a very good panorama about what is happening in Latin America, in different countries. So thank you so much for that. So I would pass the word to Emmanuel, if he could react to this wide variety of very important topics that you brought up. So please, Emmanuel, be very welcome.
Thank you. So first, I will do a quick sound and video check because the connection has been pretty unstable this morning on my end. So can you all hear and see me okay?
We can hear you well.
Okay, great. So thank you very much for the invitation and the opportunity. So I mean, I've actually learned a lot in the past 5 minutes. So thank you, Katitza, for the really good, succinct overview. I mean, so I and Data Pop Alliance have been working on questions of data sharing, data usage in Latin America for about 6-7 years, and we also work in Sub-Saharan Africa, and I'm based in New York, but I'm French, and so when I think about those topics, I try also to do so in a sort of like comparative perspective. So looking at and thinking about the extent and ways in which so the GDPR and its principles have an influence on the legal frameworks and the new emerging data strategies that we see in a lot of regions, so Sub-Saharan Africa, Latin America, as was just mentioned. So I think one first thing that I want to stress and echo what was just said is that it's of course very difficult. I mean, it's impossible to disentangle the legal side from the whole context of these regions. And so in particular, I will say a few words about Latin America, but the same considerations and arguments obviously apply to Sub-Saharan Africa, to the MENA region, to Asia. And so in particular, yes, I mean, the fact that if we talk about politics, so the fact that, as was just mentioned, very forcefully and clearly, the history of military dictatorships in Latin America, I think, plays a big role in how citizens approach these questions, and how groups approach these questions. So there is, in general, and that would be like my sort of insider perspective, and I'm happy to discuss and be corrected if I'm wrong. But I think there is a significant level of skepticism of large parts of the population, at least those who are aware of these debates, about attempts at collecting data, sharing data. These are regions where a lot of people, I mean, social media penetration is very high, cell phone penetration is very high, and so they're really, and there are lots of civil society organizations that work on these topics. So it's a very vibrant tech data ecosystem, and people are very tech and data savvy. But in general, they are worried and wary about surveillance. The other aspect is that it's a very diverse region, of course, and so in economic terms in particular, and so we mentioned the big economies of Colombia, of Chile, of Argentina, of Mexico, and a couple others, but there are very large differences in income, in levels of development, and of course that translates in lots of the areas, including in terms of the maturity of the legal frameworks and the more like general discussions. So in particular, when it comes to, I can give you one example of Colombia, where so we started working in Colombia in 2013-14, and Colombia is sort of like clearly one of the 2 or 3 countries at the avant-garde of these questions in Latin America. It's become an OECD country. It has tried to take into account, I would say, like that. So the GDPR for several years. There are, of course, big companies that are European companies that operate in Colombia. So Telefonica being one. But what we realized is that, very concretely, in running projects, sometimes there was a lot of uncertainty and there was a lot of unclarity of actually which legal framework applied, whether Colombian law was less, we say, like stringent on questions of data protection and the role of data controllers. And so we found ourselves in very interesting discussions where, for a specific project, for example, we had lawyers involved, Colombian lawyers, French lawyers, and they discussed, and they couldn't really agree on, for example, a specific project was handling personal data, or if it were no longer personal data. And so those are like very fine kind of like legal debates. But it just stressed the fact that there is no yet, I think, clear legal frameworks, or maybe not enough understanding of what exactly which legal framework applies in which context. So it's also a question of maturation. It's also a question of I would say, like internal culture. But again, even in these companies or even with government institutions, there is still a great deal of, I would say, skepticism, resistance, fear. And there's also the fear, I think, the fear of corruption. There's the fear of being accused of mishandling of data or information, which I think is quite pervasive in several countries. And I will end by saying that, for me, there is the question of data use, and I think we'll come to that in the second part. But there is a tremendous value that can be produced by actually sharing and using data, more and better in privacy-preserving ways in Latin America. And sometimes it's not personal data; it can be data between agencies, and that does not happen for a whole host of reasons: technological, technical, economic, cultural. But I think I would stress this question of culture. That there is a bit of in some countries a culture of secrecy. There is a culture of a bit of skepticism, and so we are right in this big question of the tension, like the tension between, the EU, as recently as last week, is pushing for more data sharing. Sharing data information is good; it needs to flow, it needs to fuel better human systems. But at the same time, we know, especially that centralized models of data sharing are very risky from a privacy standpoint. And so my really last comment for now is that I think there's a need for citizens and civil society groups to be more involved, to be more aware. We sort of all know that, but even in Europe, it's difficult for citizens to actually have the time to just worry and care about those things and to really weigh in. And that's the spirit of the GDPR. It's not about, it is of course about data protection, but it is about privacy, and it's about privacy as agency, where people, data sets, need to have a say somehow, and the somehow is difficult, in how their and our data are used, and not just protected in silos, but used for like positive goals. And so I think that's the sort of like the challenge of the next decade, to find that balance and the technological and governance systems that will enable this like safe data sharing.
Excellent. Thank you so much, Emmanuel. I think that was a very good compliment to Katitza's inputs as well. Thank you so much for that. And your insights are being so good that are really facilitating my role as a moderator, because you're giving me just the right hints for me to pass the word. And I would just take from what you said about culture at one hand, and citizens on the other. Many of you have been contributing to the field of digital rights for many years right now. You're already there. And I want to pass the word to Bertoni, because he's not an exception. He's contributing for many years right now. So a very good perspective in the region as well. So Bertoni, I would like to ask you exactly this. How do you think culture plays a role in what we are talking about right now concerning data protection, governance, enforcement? How do you perceive it in Latin America? If you think the pillar of general data protection bills, they can really empower citizens in that sense, as like a human value as well. And how do you perceive culture as playing a role on that, in the way citizens are absorbing these new regulations in Latin America, depending on the country, of course. And how do you relate it to enforcement in the region as well, comparing to what we are having in Europe right now?
Going back to your question, Eduardo, and thank you very much for this kind invitation. And it's a real pleasure for me to be with Estelle and Katitza and also Eloy. I'm not sure if I'm going to touch the thing about the culture, but I think that this is a very broad thing, and I'm not sure if I am very well prepared to talk about the culture in Latin America. It's very usual that people think that Latin America is one country, it's a block, that we have the same culture, we have the same, and that is not the case. When we talk about Latin America, sometimes it's better to talk paying attention to the different countries. But let me mention some things that are related to what we were discussing. And for example, the first thing is the impact of the Gdpr in Latin America. Of course, it's a very important impact, and I want to add some information or some things that took place in Latin America during the last years. For example, many people know that in Latin America we have what is called the Ibero-America network of data protection authorities. We try to emulate in some way, without the same teeth that they used to have, the working party of Article 29. Well, coming through the Ibero-American network, we approved a couple of years ago the Ibero-American standards for data protection, and those standards were very similar in some way to the GDPR. It was not a cut and paste, but they were very similar. And this is a document that has been used in many countries, including in my country, and I'm going to some explanation of what's going on in Argentina. We, as the data protection authorities, worked on a specific draft to change our law. Our law is coming from the year 2000, so it's an old law that has some problems. One of the problems is the amount of the fines that we can put, and I will talk on this at the end when I talk about enforcement as well, which is the other thing that we have been talking here. And we use in Argentina these Ibero-American standards to as an inspiration for this draft. Unfortunately, the draft was not discussed in the Congress during the past 2 years. So, because of the rules of the Congress, this draft is not going to be discussed again soon. But the good news is that some legislators, reintroduced a draft that is very similar to what we have been working, and that draft also have some similarities with GDPR. The same is going on in different countries. Katitza explained very well. Actually, in Chile, for example, Chile has been debating for a new data protection law for years, and we are waiting for the new data protection law in Chile for years, and they were paying attention very closely to the GDPR. Why is that important in our perspective? We really think, or I really think, that it's very difficult to protect, to defend digital rights, but particularly the right to privacy, if we don't have some sort of common standards around the globe. That is why it is important, the GDPR, in terms of the adequacy decision, and that is why it is important, for example, the Convention 108 Plus coming from the Council of Europe. Argentina is a state party of the Convention 108, and the Convention 108 Plus has been already signed by the former president of Argentina, and the new president of Argentina sent for ratification to the Congress. So, I mean, we need to, including in terms of enforcement, is very, very important to have this kind of common standards, cooperation, because it's really impossible to think that we are going to be effective in protecting data protection, privacy, digital rights, just in one country. It's for me that's impossible. The other thing is in terms of, and I'm going step by step, going to the question about culture. What people cares more in Latin America when personal data is processed by the private companies or by the government. And that depends on the countries, and that depends globally. I might say it depends on the regions and depends on the countries. In some situations, people are very concerned when the government is, collecting data and using data more than when the private companies are doing that. And in other countries, in my perspective, it's what is happening is exactly the opposite. People don't care if the private sector collect data for processing, but they really have concerns when the governments are doing so. So, I mean, and this probably, yes, it is a cultural issue in Latin America. We are coming in many countries from dictatorships, from strong state surveillance, and that is why in some of our countries the concern is more concentrated in how the governments are using personal data than how the private sector is using personal data. But again, I cannot do a generalization of that. If you ask people in different countries, maybe you are going to receive different answers on that. So what we are doing as data protection authorities under these realities in terms of enforcement, when I can talk about my experience as the data protection authority in Argentina, particularly where during this year, this unusual year, because of the massive data collection of people with the goal to fight the pandemic, we were working very close to what the government is doing and also what the private sector is doing. We were given, for example, some recommendations when the government developed some applications related to the COVID-19. And in terms of law enforcement agency, I might say that we did two important decisions this year. Where one is that we sanctioned the federal police of Argentina because of a breach of security that it was not new. But at the end of the day, the Data Protection Authority in Argentina has the power to sanction the federal police, and we did that. And the other thing is that many people were, particularly activists, the civil society, were very concerned about a decision of the Ministry of Security to put in place what they call, I don't like really don't like the name, but it's like something like a cyber surveillance protocol for the law enforcement agency. We intervened there, and we specifically request the suspension of the application of the protocol. And we are in discussion now with the Ministry of Security. Of course, we need the support of activist civil society for that goal. But this is what we were doing in terms of enforcement, if I may say. We have a lot of challenges for the future as data protection authorities as well. Again, in terms of enforcement. One is how we are going to control that the amount of data that has been collected because of COVID-19 will be erased, will not be used in the future. And this is something that I think that will be one of the bigger challenge for data protection authorities in the future, because it is possible to accept that the collection of data protection during this emergency is possible under the law, but what it is not possible to accept is that this amount of data is going to be used in the future when the pandemic, I hope, disappear. This is the challenge for the future. And to finish with your question, Eduardo, I mean, I think that one important thing in Latin America in general, in terms of culture, is to work more in the feeling of the people about the importance of protecting their personal data and their privacy. Why I'm saying that? We did a survey last year, and everybody responded that they care for their privacy. Everybody responded, not everybody, I'm generalizing, but a huge amount of people say that they care about the protection of their data, the protection of their privacy. This survey is published in our website. But the problem is when I put this apparently complete agreement in practical terms. We did not receive the nouns of people when they feel that their data protection or their personal data has been violated. We receive few denounce or complaints in our agency, and the same is going on with the courts. So I think that we need more there. We need more in terms of strengthen the idea that the data protection authorities have to be independent to do what we are doing, and the importance that people know that they have a body that can help to protect their rights. If it is not the data protection authorities, are the courts. But we need more in terms of cultural, change, more activism, in my view, coming from the people when they really feel that their data is not protected. Go to the courts, go to the data protection authorities if they really believe that this is important for them. And I stop there. Thank you.
Excellent, Bertoni. Thank you so much for your insightful inputs as well. And you gave us so much interesting information about standards, cooperation, the importance of us having like independent authorities. And I want to explore a bit more the approach about the culture. Of course, in different countries in Latin America, we cannot put all together, but it's important for us to discuss in each one what is happening. And I'll provoke Emmanuel, Katitza, and Estelle to dig a bit deeper in this other perspective about culture, not only talking about data protection, but instead thinking about how data protection relates to digital rights. For example, I had the happiness to participate in the development of the Internet Bill of Rights in Brazil that was 12 years ago, building up this culture about digitalization in Brazil and how it's attached to human rights of the users as well, and many important principles like net neutrality, freedom of expression online, so on and so forth. So I would ask you to relate what we are discussing now with this idea of relating data protection to digital rights at one hand, but also trying to bring this cultural perspective, as Katitza mentioned about what is happening in Brazil, and that one I can speak for myself because this is where I come from, of course. Like what we are having with data protection authority that is linked to the presidency of the Republic. And our general data protection bill was meant to regulate also public entities. And it's linked to the intelligence agency. So how it's going to play out in Brazil, we are a bit concerned about it. So trying to tackle in different countries in Latin America. But I also want to bring back another point from Katitza that talked about criminal investigations, because it has like a clear interface with data protection. And coming back to Estelle, trying to explain for us what are the impacts of the Max Schrems cases, for instance, where Europe sent a very clear message to the US in that case, but in one sense to the whole world, that the standard of data governance and the protection of the citizens must be maintained, even though we are talking about criminal investigations, as Katitza was mentioning, and even though we're talking about national intelligence agencies eager to investigate different things. The pillar of data governance have still to be maintained somehow. So the question to you three is, how do you perceive the culture playing a role in different countries concerning that, the protection of the citizens, but also in criminal investigations, the impact and messages upon the Max Schrems 2 cases? So let's start with Estelle, please.
Thank you. I will address 3 points from what you just mentioned. First, this cultural approach, maybe from a year perspective. Then I want to re-up a little point linked to that on the independence of the Data Protection Authority and a little bit what we have experienced here, but link it to what's happening also in Latin America, and last, obviously, the Schrems. So first on the culture of understanding data protection and how it relates to digital rights. I think if you come from a European perspective, data protection is a full fundamental right in itself. For many countries, it's really, really linked to the right to privacy. It's also the case for us, but we have under the EU Charter, those two separate rights that reinforces each other, but at the same time also have their own legal framework. So the Gdpr protects the right to data protection, and we have another framework that protects the right to privacy. And I think this is not only a strong message to reaffirm that data is a component of your privacy, of your private life, but it's not all of it. And at the same time that it has this fundamental importance because it's really about you, about who you are, and about protecting the core to yourself. And so when we have those discussions about even within Europe what data protection means, you do see a little bit of a difference, I think, culturally from countries who have suffered exploitation of their data historically, countries where governments try to exploit that information as well. So that's the case of Germany, of course, but France also in the 70s, and countries that have suffered dictatorship. But in other countries that were also under the Russian influence and under the Soviet Union, I think the sense of privacy and data protection is also really strong there. What sometimes we're missing is like not every country, not every European country will call it the same way. You know, you want to have a freedom to be left alone from the government. You want to make sure that no company shares back the information. And I think one point that Eduardo Magrani was mentioning of like, you know, this attitude of sometimes you're more worried about the government or the company. It is a valid point, and it's also existing in Europe, but we need to make sure that actually data protection principle apply to both, to any entity. It doesn't matter if you're a public or private. Like you can't infringe on those fundamental rights, no matter what's your status. Obviously, there are certain reasons for which maybe on certain cases in Europe, like government can have access to more personal information because they needed to give you access to welfare system, et cetera, et cetera. But this still needs to be regulated, and it cannot be a blank check. And that was tested for us during the COVID-19 crisis in Hungary, for instance, where the government decided to pull a full exception on data protection rights, saying that they would no longer apply the rights under GDPR because they needed to access data during the pandemic. And every other country in Europe were able to do that while still respecting GDPR. So that was not a valid argument. And here we started to see a little bit of the cracks of how much sometimes country wants to keep power and how much data protection is actually an important tool for people to remain in control of their life and of their rights in the digital era, and how data protection and privacy really are enabler to many other rights, many other fundamental rights. This question, what happened in Hungary, also showed us some of the cracks of the independence of our DPAs. Independence for us is something that needs to be guaranteed in statute, which can mean different things in different countries. It means usually you're named by one elected body, you're removed by another elected body, or you may be named by the head of state, but then there is more checks and balance that needs to be in place. But really what we saw during the crisis in Hungary on that case is that the DPA was defending the state, when its role is the DPA was not here to give excuses of why the state was doing this, but to investigate whether or not it was proportionate, which it didn't do. And so even having, those models in place, we were faced with an issue of guaranteeing independence, even in practice, is very difficult, which is why what's happening in Brazil for us is really, really worrying. And thanks, Katitza, for raising this up, because again, Brazil did a lot of effort in adopting a legislation that on paper is really great, but if you task the enforcement to a group of people who are more used to see privacy as an impediment and are always thinking with a surveillance and defense mindset and have very little expertise in protecting human rights, then they're not going to be the best place to protect people's rights in this situation, and they will have an interest to defend more the government interest of harvesting more information for surveillance purposes, and so the balance is completely shifted. So we wrote this letter to the body of global DPA, the Global Privacy Assembly, to the European Commission as well, and the Council of Europe, to ask them to really warn them of cooperation with the Brazilian DPA in that state, because we don't think it can be an independent authority given the link to the state, but also we don't think it's equipped to protect people. And so we're not saying don't talk to them, but we're saying actually engage with the government, knowing those shortcomings, and engage to change those, because it would be a missed opportunity if after so many years Brazil does so much work to develop a robust data protection authority that is actually put in a way that gives more control to the government rather than giving more control to people. It's about protecting people and empowering them. Which going into those surveillance question moves to the Schrems decision. And I think for us, the Schrems 2 decision was a confirmation of many years of jurisprudence from the court that surveillance harmed fundamental rights, and it also harmed businesses if you don't take it seriously enough. And so it was not a surprise for us that the court took the decision to invalidate the deal that used to allow data to flow freely between the EU and the US. The same thing happened 5 years ago. No reform happened. We knew we were going to be in the same situation. We understand those conversations are complicated because, as you mentioned, it touches the core of national security. Really tough question. You have to rethink the way you've done national security because it's gone too far and it's eroding privacy globally. But if you don't do that, you're not only going to impact fundamental rights of citizens in Europe, but also elsewhere, but you're also going to harm actually the way platform works, because then the internet is built on free flow of information, and you're going to prevent this from happening because you're undermining the backbone of this economy. And so I understand the way that sometimes the US would want to portray this as an anti-American approach from the EU, but it's a value-based approach where we're reinforcing our rights, and it's also pushing for this global convergence and global conversation on privacy. It's not anti-US. We've taken the same decision against our own national security laws in France and in the UK even recently. Surveillance is an issue, and we need to have this conversation instead of trying to find political maneuvers around it. And this did not happen 5 years ago, and this is really what the next year actually needs to be about, a serious conversation of how much surveillance has been eroding privacy. And if we don't have this, as Katitza mentioned, we're going to have data protection law in the commercial sense, and then surveillance continue growing from the states. And this is not acceptable because they also feed from the harvesting practices for companies. So you can never have one without the other. The two needs to come together if we really want to have an internet and a global economy that is respecting rights and empowering people. I'm going to conclude on that, but we keep hearing government and company telling us that we need to trust them and we need to fully trust the digital economy. We can't do that if we know all of them are surveilling us in one way or another. You can't ask for a trust. You need to demonstrate that we can trust you. And this needs to happen through robust privacy reform and through surveillance reform. If not, you're just going to be here 5 years from now talking about Trump 3.
Perfect. Thank you so much for this fantastic debate that you are providing. So I'll pass right away the word to Katitza, please.
Okay, I'm going to talk about two issues, just the cultural approach to, and the second one just focus on the Trump's decisions.
Perfect. I would just ask you to be a little bit more brief for us to have that we are able to react to some Q&As, please.
Okay, cool. So on the cultural approach, just from a Latin American perspective, although there are many organizations working on this, data protection is in many constitutions a fundamental right. And when the Constitution hasn't recognized explicitly a fundamental right, the Constitutional Tribunal has done so, or we have the figure of habeas data. So I think that it's not a matter of culture. I think when it comes to a violation either of privacy or data protection, the user is affected and needs a right to redress and a way of also protecting their rights a priori. And that's why these two rights are complemented each other, either as an umbrella right or as two different rights, depending on the country. Like Eduardo said, we don't have a European Union. We don't have a regulation that every state has to comply. So what really is different in Latin America is that each country law differs a lot, country by country. Just to point out Colombia, as it was mentioned by the previous speaker, they also have their adequacy standards. In the list of adequate countries are countries that are not adequate for the European Union. Like there are other free countries like Peru, Mexico, and Colombia, and in addition, and the United States. And the European Union hasn't granted an adequacy decision to Colombia either. So the standards differ very vastly. Now, going back to the case of the Trump decision, I think this is great because one of the key fundamental principles that brought up the Trumps is that access to data on a generalized basis compromises the essence of fundamental rights. And they argue very well that the U.S. law in NSA surveillance cannot provide that essential equivalent level of protection. And we see in Latin America many countries' laws that have this unrestricted access too. Like we have it there is a transparency report from Millicom Telefonica that says there are direct access to the servers in Colombia and in Central America. We have also hacking team links that says that all the traffic from the fiber optic cables are passing through the U.S. Embassy in Colombia. We also learned through the Snowden leaks that, for instance, the NSA is intercepting all the cell communications through a backdoor that they got from the DEA. They actually appear to have access legally obtained that in cooperation with the U.S. Drug Enforcement Agency to open a backdoor to spy on all the cell phone networks in that country. And this program about tapping on fiber optic cables is done abroad. And it's done in domestic countries. In many Latin American countries, there is this program from the NSA that is called Mystic. The Intercept has learned that it's used to monitor all the traffic also in Mexico. And it's used in all the countries that have more than 250 million of people. And so when it comes to government collection of data, when it comes to the NSA, when the NSA can do whatever they want when they are outside the US. So if data is stored in any country outside the United States, they have carte blanche for spying. And they are doing it a lot. This is some of cases that are explaining, but they are also hacking on largest companies like Gemalto in the Netherlands to try to steal the encryption keys and then spy on all the internal computer networks of the companies. And this company, Gemalto, manufactures the chips of the SIM cards. By having the encryption keys, they can spy on the networks of all these carriers. And these carriers are around the world, in more than 450 companies around the world. So back to the point about the Trumps, they create this amazing opportunity to put restriction and teeth to these types of unrestricted access to data, either domestic, compelled by the government at the domestic level in several Latin American companies, but also by these onward transfers that can happen between the Drug Enforcement Agency and the cooperation they have with local companies. There is a lot of programs about the Drug Enforcement Agency in Latin America throughout the region. Just to conclude on this, I think that it's very important that we actually fix things, because the church decisions make at the core is that they want to protect fundamental rights, that unrestricted access violates human rights. And we hope that the EDPB come with solutions that actually try to solve the problem and not put band-aids that will not solve the problem, like compelling storing data in another country. Why? Because exactly that's what the NSA wants. The NSA wants they are free for all, no restrictions. And as we see with all the leaks, it's happening in most Latin American countries in alliance with the Drug Enforcement Agency. So there are many things that they are requiring that are very important. Like, for instance, the DPD come to compel companies to store data at rest, and that's great. That's actually effective method to protect the data. I think that we need to have a broader conversations, because this free-for-all spying is happening around the world, and I don't think even just data protection law will try to restrain it. We need that, but we need more to put teeth to all these intelligence agencies that are doing this in cooperation with private sector around the world. And I just
Thank you so much,
Katitza.
Go on. Yes. Thank you so much.
Also, this is my personal opinion, EFF opinion, but I'm not talking on behalf of anybody. Yeah.
For sure. We have roughly 5 minutes to conclude our session. So far, thank you so much for the very deep conversation that we're having here. And Katitza, thank you for your inputs. I think you're not only a great expert, but also visionary, because without knowing, you already addressed some of the questions that we have. So I'll pass the word to Emmanuel, but already addressing some of the questions that I have here on our Q&A. So I would ask you, for example, Geraldine question: recent calls against encrypted messenger services after terror attacks in Germany, how to balance civil liberties and the need for better information coordination. Katitza also addressed some of that. And how can civil society create checks and balances given lack of funding and other constraints? And then I'll have like a round of final comments, just very, very briefly, 1 minute each one, please. Please, Emmanuel. I think you're muted, sorry.
Of course, I'm muted. Sorry. Yeah, so I don't know where to start and end, but okay. So in 1 minute, yeah, I mean those things are very very deeply cultural. In 2013, so I was in the U.S. when the Snowden revelations came to light, and a lot of my friends around me, pretty. We would say, liberal, educated people didn't really see the problem with the surveillance activities, and it's because there is a very powerful apparatus at play in the U.S. still about convincing people that this is done for their own good. They have nothing to hide, etc. But I mean that has changed, of course, over the past 5 years, and a lot of people increasingly around the world are fed up with surveillance, with commercialization of data. So yeah, definitely there's been a lot of changes, and this is, I think, spreading around the world, and this is very very welcome, of course. Now at the same time, there's also the data usage part that I want to come back to. I think data is a very powerful tool. Of course, for bad, of course, obviously, but I think it's a very powerful lens on the world, and so these personal data, do contain a lot of very valuable information about the state of our human societies, and so and they can help fight corruption. They can reveal fault lines that COVID has exacerbated, but also laid bare, and so we need to find. We're collectively working, I think, towards trying to find this balance and the right mechanisms. It's not just a question about theoretical balance. What is to what extent it's there. We need to find technological systems, legal and regulatory frameworks. And I will end by saying the key, I think, for me in a sense, save or foster democracy as government by discussion. Is to find the right way to involve citizens, data subjects, and civil society organizations, which are, I think, almost nowhere to be seen or heard in many, many, many countries. And so that's, for me, I think, the big question of the next decade, which is how to concretely give more voice to citizens about whether, how, when our data in particular are used to address some of the key challenges that COVID in particular has exposed. Now
Thank you very much, Emmanuel. 1 minute to go. I received one question here about what changed after GDPR, but I think you already addressed this a lot. So since we are on time to finalize our panel, I would just to make the final remarks here. Thanking you, all of you, for your excellent inputs. You really did a very good job. It was a pleasure to be here with you in this very insightful and deep conversation. And thanks for the organizers as well for all the support that you gave us. And yeah, if you have any further doubts, please reach us out, send your comments, follow everyone on the social networks, because it probably will have a good data enforcement behind it after this panel, right? So thank you once again, all the speakers. It's a pleasure to be here with you.
Thank you all. And yeah, happy holidays. Be safe. Thank you.
Thank you very much. Bye-bye, guys.